wondered what would happen if you became physically or mentally incapable of making decisions? What would happen if you had a car accident and were seriously injured, or had a stroke and were left disabled? These events can touch anyone at any time. But the older you get, the more likely it is that some disability will affect you, whether it's hearing, eyesight, mobility or memory problems. If you've not planned ahead, your loved ones can't simply turn up and access your accounts to pay bills, deal with your tax affairs or make arrangements for your care. They can't make sure the treating doctor doesn't give you a particular treatment. It may mean they have to get a court order to make these decisions. There are some significant problems to leaving it to chance. It's costly. Court fees, medical fees, mandatory insurance and supervision fees can run into thousands of pounds. It's a lengthy process. It can take in the region of 6 months for the court to make an order. The court takes control on who and how many people to appoint, what types of decisions can be made, and may require the production of formal yearly accounts. Instead of leaving it to chance, you can take control rather than losing control by making a lasting power of attorney. It's a legal document that allows you to choose who and how many people, known as your attorneys, should make decisions on your behalf, when and how they can make decisions, what decisions you want them to make, and those you don't. By making a lasting power of attorney, your attorney will be ready to act within weeks rather than months, at a fraction of the cost of a court order. There are 2 types of lasting power of attorney you could make. A property and financial affairs power enables your chosen attorney to make financial decisions. It could be used if you're physically or mentally unable to make decisions. Your attorney could deal with your savings and investments, pensions and liabilities. They may even sell your home, which of course might be necessary, so you could buy a more suitable property. A health and welfare power enables your chosen attorney to make decisions about your welfare, such as where you live, and healthcare, such as treatment and medical procedures. It could extend to refusing life-sustaining treatment on your behalf. This power, unlike the financial power, can only be used when you are mentally unable to make decisions. Most people choose a close family member, a friend, and sometimes a professional, such as a solicitor or accountant. Whoever you choose, you must be sure you trust them. They would be stepping into your shoes. Ask yourself, do they have the time and the ability to be involved? Have they a good track record managing their own finances? Have they made decisions in the past which have made you question their judgment? Fortunately, most people don't have a problem making this choice, as they tend to appoint close and trustworthy family members. If you want more than one attorney, do you want them to make all decisions together, or perhaps some separately? Making all decisions together can cause delay, and if they can't agree, some decisions may never be made. If an attorney wants to retire from the role or they die, then decisions can't be made and the power may end. If you're concerned about this, it would be better for them to make decisions together and separately, known formally as joint and severally. You might also want to appoint a replacement in case an original attorney is permanently unable to act. Lasting powers have some special safeguards. You choose someone independent to provide a certificate confirming you understand the power and aren't being pressured into making it. It could be someone who knows you well, or a specialist professional such as a solicitor or doctor who will be familiar with the role. It can't be a member of your family or your attorney's family. The power must be registered with the Office of the Public Guardian before it can be used. That office can investigate concerns about how the attorney makes decisions and so provide some insurance to protect you from abuse. You choose people to be told about the power when it's being registered, so they can raise any concerns which they might have. You can choose absolutely anyone, provided it's not your original or replacement attorneys. Perhaps a friend, your doctor, or a work colleague, but make sure it's someone who you know will look out for you. Your attorney must make decisions in accordance with the Mental Capacity Act and follow its code of practice, in particular when making decisions which must be in your best interests and not theirs. A member of Solicitors for the Elderly can help and advise you about making a lasting power. Each member is legally qualified, properly regulated and trained to advise in this specialist area of law. Their extensive experience will ensure that your power works in practice and potential problems are avoided. There are some situations when it's highly important that you obtain legal advice, particularly if you're uncertain as to who should be your attorney. You want to include conditions, restrictions or guidance about when your attorneys can act or how they act. You want advice about how your attorneys go about making decisions. Your family don't always get on with each other. Your family live abroad. You've substantial or complex assets. You've property abroad or own a business. You're a trustee of a trust holding assets on behalf of another person or in joint names. You're in hospital or a care home and may need extra support in making the power. You've a condition or diagnosis which may cause others to question your ability to make the power. Making a lasting power is an important decision and shouldn't be taken lightly. It's better to make the power sooner rather than later, when you may be going through a crisis and find it harder to think clearly. It's better to take control and make a lasting power, rather than lose control and let a court make your decisions.